And welcome back to Brashenomics. I'm Ben Brashen. And, you know, it's Seafair. Everybody gets excited for Seafair. And so I figured, you know, we talk about things that you kind of need to start thinking about. Not just once, like the first time you went to Seafair, not like the first time you saw the Blue Angels, but every single year, like the second and third and fourth time you saw the Blue Angels, or 25th time. I don't know how many years you guys have all seen the Blue Angels. I've seen them lots. But when you start looking at Blue Angels, it's easy to look forward to the fun stuff. Everybody looks forward to the holidays, but people don't always look forward to kind of the maintenance stuff that you have to do. John Hugg joins us, attorney at law, specializing in estate planning, business succession planning, and elder law. He's also a frequent speaker on these issues and hosts of informational seminars throughout the Seattle area. Hello, John.
Hello, Ben.
How you doing? Yeah, well, thanks for coming.
Yeah.
And, you know, understanding estate plans is something that nobody looks forward to like they do to Seafair. Nobody's like, yeah, I'm going to go do an estate plan today, man. This is going to be awesome.
Nobody ever does.
No.
No. Most people put it off, of course. And I think that's just the nature of the beast. I mean, it's not the most fun thing to do. And then when you dive into it, you realize that maybe it's a little more complicated than you thought it was. And so, then it's even less fun. So.
But you do kind of come out the other end with a feeling of, you know, you've accomplished something that is important.
Absolutely. And it is important to do. We've talked about it a number of times, to have all of your affairs in order, you know, have your wills in place, your other documents in place. But one of the other things that you need to do when you're going through that process is to think about coordinating your other assets and how that will fit with your estate plan. And
doesn't that, I mean, this is something, since your assets change continuously,
mm-hmm.
I suppose they change every time you buy something or get a paycheck. But because they're changing consistently, isn't that something you should be doing more often than just a set and forget type of structure?
Well, I suppose it depends on what we're talking about in terms of assets. I mean, yes, you're going to be buying things all the time. The new flat screen TV, that's something new. The new couch, whatever it might be, the new car, those are new assets technically. Coffee, yeah. But those aren't really what I'm really thinking of. Those are going to change, and most of those things you don't really need to worry too much about. I'm a little bit more focusing on assets as in your life insurance, your real estate, your 401k, your IRA, those types of things, and making sure that those assets fit with what you're trying to do with your estate plan. There's a lot of everyday transactions that can occur that can dramatically affect your estate plan. So just to back up before I dive into that, is your assets can pass to other people by operating something other than your will. So if you don't coordinate things correctly, you can wind up with having too many assets going to one person or no assets going to another person because you think you've got things covered in your will, but you really don't. So one real life example. There was this guy that I know him really, really well. And he was about to buy a house. And at the time he was engaged to be married, and he and his fiancée were going to go buy the house. Went to closing. Escrow agent passes across the table, here's your deed. This is what you're going to get and how you're going to take title. And it said joint tenancy with right of survivorship. And the guy, well, he'd been to law school at some point in his life, said, no, that's not right. Who told you to do that? Well, nobody. We just assumed that's what you'd want. Well, that wasn't what he wanted, because his fiancée had a child from a previous marriage. And so what he wanted to do was make sure that his share of the real estate would be put into a trust for his wife, and then at a later point in time, he knows that it's going to make its way back to his children, down the line, and it doesn't get confused. But that plan would have been overridden and frustrated by the joint tenancy with right of survivorship language, which the way that would have operated is if he died, everything would have automatically passed over to his fiancée. Yeah, exactly.
I bet that. So, I mean, it comes down to these things that happen, and people assume they're right.
Right. A lot of times they'll assume something is right, and certainly not everybody sitting down to close on a house has gone to law school and knows the difference between a joint tenancy with right of survivorship and a tenancy in common and the legal ramifications of what that means. So yeah, it's some of these things you take things for granted a lot of times, and don't think about really what the end result could be.
So it seems that if you don't take into consideration what happens after, if you die, and you're not more focused on kind of these different aspects, life insurance, or as you talked about, a house, or I guess it could be an IRA, 401k, whatever your assets, your bigger assets are, you can really put somebody who you don't mean to in a bind because of it. And it's, you don't want to call it ignorance, but in some ways it's just, there's some apathy towards just thinking it will go the right way. There's almost optimism.
Exactly. I mean, probably an even more simple, more basic scenario that was probably occurring at this very instant somewhere, at some place, is somebody's husband and wife are opening up a bank account right now. And more than likely, the young party on the other side of the table is setting up a joint account or a joint tenancy account where, it's going to pass automatically from, one joint tenant to the other, one spouse to the other upon death. Now, in a lot of cases, that can be really a beneficial thing. So I'm not telling you don't ever set up a joint tenancy account. That's not what I'm saying. But it's going to basically depend on the circumstance. So if you've got a checking account with your wife and there's $10,000 or $20,000 in it, that would probably be a very good thing to set up as a joint tenancy because you pass away, everything automatically passes to her. She's got money to live on until things start to smooth out through the probate process. But on the flip side, if you've got $200,000 in a savings account, joint tenancy, and you want to use some of that money to go to someone other than your spouse, and it's in joint tenancy, then that's probably going to override what you put in your will. And
so that money doesn't actually make it. It doesn't make it to the will process, to probate.
Exactly, because those are non-probate assets. Assets such as life insurance, IRAs, 401ks, joint tenancy accounts. Those are all non-probate assets that, in general, are not going to pass through your will.
But don't a lot of these have? I mean, don't they have like specific beneficiaries?
Absolutely, and that's where you want to make sure that things are matching up the way you want them to. A lot of people that come to me, it's not too terribly difficult. You've got your spouse named as your beneficiary on your life insurance. Well, that's where you want everything to go. So your will says I leave everything to my spouse if he or she survives me. So everything is fine, no problems there. Your IRAs are probably going to say much the same thing. Where some issues pop up would be with contingent beneficiaries. If your spouse is not, does not survive you, then where does it go? If you don't have a will, you might say you leave everything to your children in equal shares. If your children are still minors, then you'll probably have to have a guardianship put in place to oversee the money that they received until they reach the age of 18 when they get everything outright. So the better way to go with that would be to have a will and to have a trust for your children set up until a specific age, 18 or older usually, and have the assets go there as a contingent beneficiary as opposed to them outright.
So really, I mean, it comes down to simplify this a little bit, there is a lot of complex movement in moving money around when somebody passes.
Absolutely. And then to make sure that it's going to move where you think it's going to move, you do need to do that planning and probably do things and keep things up to date.
Does a will almost act, when you have your will, does it almost act as, I guess, you start realizing, okay, the beneficiary is named and now it's also in the will. I mean, is it almost like it's like a checkup in some ways? Like, okay, yep, check, that's where you want to go, check.
Right.
As you revisit it?
Well, you can do that as sort of maybe a fail-safe, but that's, unless you specifically do certain things with your will that would potentially override certain beneficiary designations. The beneficiary designations in your life insurance and payable on death accounts with banks or brokerage firms and whatnot, wherever that is designated, that is most likely where it's going to go.
So what if they conflict?
Well, that's where you have to keep things up to date. If they conflict, then you basically have to figure out what you want to do. An easy example, if you've got one child with, let's just say that, one child is going to get the entire IRA, $500,000 IRA, another child gets the house. Then the house is, sold, or it's leveraged. Now it's not an equal distribution. Well, now you might want to figure out, well, this isn't equal, but I want an even distribution between my kids. So now you probably are going to have to alter things, something in some way.
So like a life insurance piece, right? I mean, yeah. I guess if you have life insurance and then you have two kids, I mean, that's one of those pieces, right? Like, I mean, mine right now would be to my one kid. If when we have another kid, I guess you want to make sure it's split up.
True. And again, going back, I mean, personally, I think you should have a trust for your kid, and that's where the money should go, and then have the trust set up to manage, for both kids.
Perfect.
And that would be the way that
and then you can actually manage that money and where it goes and why, and it puts you in a little bit more control.
Absolutely.
Good. I mean, it is. It's hard to put yourself in those positions if you're gone. But if you don't take that time to do that checkup, and then as things change, to just continually check in and make sure that, you have your documents in order and you have your affairs in order, it can be a real train wreck.
Yeah, it can. And especially if you have a significant life event, you definitely need to get in and look at all of this stuff comprehensively, and in its entirety. One thing that comes to mind is a divorce. If you are getting divorced, that's your ex-spouse. You probably don't want that anymore.
Probably not.
You can change your will, but you
we have all guys in here right now in the studio, and everybody's nodding their head.
You're probably going to want to make sure, and you definitely have to make sure that you have covered all of those other accounts, because I've got one right now, dormant bank account, but somebody incorrectly dumped money into it now that this gentleman has passed away, and we got to figure out how to get it to his real wife, not his ex-wife.
Oh, man. John, that sounds like a dilemma.
Yes.
Good luck with that. Thanks so much for joining us. John Hugg, attorney at law with Hugg & Associates, great friend of our show, and really do appreciate you coming out on here, our pre-Seafair party on the air.
Yeah, our pleasure.
Yeah. Well, hey, when we come back, another thing people do think about once a year is taxes. But almost every time you end up filing your taxes, there's something you could have done throughout the previous 12 months to save money. Points.